And we're back. Cayce Lynch, welcome to the show.
Thank you so much for having me, Nick.
We start all of these off, Cayce, with allowing our guests an opportunity to introduce themselves. Who is Cayce Lynch? What is it that you do?
Oh my gosh. Well, first, I'm just so excited to be here. I am the administrative partner at Tyson and Mendes. I'm a lawyer, and we are a law firm. We're a nationwide law firm. We specialize in litigation and only the defense of litigation. We're not on the plaintiff side. We're only on the defense side. We're very honored to serve the insurance industry.
Yeah. So no lawyer jokes, I promise.
Thank
Maybe,
you.
maybe
I'm
one,
used to them though.
maybe one. Maybe we'll sneak one in.
Okay.
We'll see.
Okay.
So what drove this particular conversation was something I saw you post on nuclear verdicts, which is a big deal. It's a big deal in insurance. And I don't think we've heard about them, but because we're not in the courtroom, all we do is get to see the headlines. So we don't actually understand, as an insurance professional, I don't actually understand the dynamics around nuclear verdicts, only what I hear and read, but I have not participated in it. So what is a nuclear verdict?
Yeah. So we have I'm so excited to be able to share with you and your audience today because we have a really unique perspective on it. So not only are we on the front lines in the courtrooms facing nuclear verdicts, preventing nuclear verdicts, but we're passionate about this area of the law. We've done so much research and writing on it. We've actually trademarked the term nuclear verdicts. We've written a book on it. Book number 2 is coming out later this year. So excited. So I get to talk to you about both, right? The theory behind it and then actually what's on the front line. So what is a nuclear verdict? We define it most simply as any jury verdict in excess of $10 million. Or if you want to get a little more complicated, it's where the total award is proportionate to the facts, to the injuries, or to the economic damages sustained in the case, like the medical bills, right? So these are the cases that we see where the economic damages, somebody's past medical bills or medical treatments, like $300,000, but they got a $40 million verdict because the vast majority of that is the pain and suffering or those emotional distress awards in the case. Like that's where we're seeing the focus of these big verdicts.
Yeah. In other words, it's basically a punishment. It's so there's a computation of what the damages actually were, but there's some emotional element with the jury that's kind of we'll call it triggering. That's basically like we need to send a message,
Oh,
sort of thing.
you just hit the head on the head, nail on the head there, Nick. So it is plaintiffs' attorneys know that the best way to get paid is to ask for a big dollar, right? And even in cases where we don't have punitive damages, so the law provides for different kind of pockets and categories of information. And punitive damages are only available in like egregious conduct or
Mhm.
fraudulent situations, right? But nevertheless, plaintiffs' attorneys, and we can talk about why in a minute, but plaintiffs' attorneys know that's how they get paid. So they've essentially turned the pain and suffering element, the non-economic damages, into an element of punishment where the juries, along the reptile theory lines, exactly what you said, Nick, are trying to send a message that we're going to hold this defendant corporation accountable. We're going to send a message that this is not the kind of conduct that we tolerate in our community. And juries, which we can talk about, true, feeling these different emotions, are empowered to just send a message and give a big verdict. And to them, at the end of a long trial, that's justice, right? And they've had the power to bring about fairness and equity.
Is it admissible for a defendant or for information about a defendant for the insurance information about the defendant to come up? Because I'm wondering because I have heard that if if the jury knows there's an insurance company involved, it changes some stuff because they're like, oh, there's another pocket that that's potentially available here. Is that admissible?
No. So the juries will go through 2, 4, 6, 8 weeks of trial, and they're not allowed, the evidence of insurance is never allowed to come in. We're not allowed to talk about it. And there's actually jury instructions, at least in California. I'm not admitted in all 50 states, but in California, where I'm admitted, that the jury cannot consider who may be paying any final verdict.
Okay.
So while some jurors may have that common sense, right? And that may come up, there's actually a jury instruction. You're not allowed to talk about it and you're not allowed to
Yeah.
consider it.
Yeah. So, what could be some common factors that lead to nuclear verdicts?
So, oh boy, like, do you want to talk about the society element and like juror perception, or you want to talk about front lines in the courtroom and what we're seeing with the plaintiff's bar? I could go both ways on this. What do you think your audience would want to hear most about?
Well,
Both? You could divide and
it
conquer.
it sounded like, the plaintiff's bar is very smart. And here in Florida, we've learned in the past few years that they have data scientists. So they are doing
Mhm.
like A/B split tests to see,
Yes.
what combination of words work. So
Hmm.
I think they're at the cutting edge of psychology in
Yes.
like what words do I use to get the jury most favorable
Yeah.
to what it is. Okay, so I'm going to set that aside.
Okay.
How do you defend against that, and what are some of the like legitimate courtroom causes of harm that could lead to a nuclear verdict?
Okay, I'm so excited you've asked this. Okay, can I ask you a question? I know this is your podcast, but may I ask you a
Yeah,
question? Okay, let's say you're a plaintiff's attorney and you've
okay.
got a jury of anywhere from 8 to 12 people, right? What emotion do you think through your arguments you need to try to get the jury to feel in order for them to go to big dollars to award a big verdict? You're trying to get them to feel something. What do you want them to feel?
Empathy, sympathy. Like if I were in their shoes.
Hmm. That is traditionally, historically, in the past 50 years, 1000% correct. In the past, like 10, 15 years, the plaintiff's bar, through all of this data scientists and all of the psychological studies that they've done, have realized that it's anger. They want a jury angry at this individual defendant or corporate defendant because anger makes people think and feel irrational, like think and act
Yeah,
irrationally,
yeah.
right? And and then in addition to fueling juror anger, they follow it up by conditioning them and talking about big dollar values. So everyday normal Americans that thank goodness show up for jury service, we need all of you, right? None of us walk in off the street thinking that a $60 million verdict is like fair and reasonable. That's funny money. Like I have no personal like reference point of what $60 million is, but the plaintiff's attorneys have ways to talk about numbers. They ask for it very early, and by the time you've heard $60 million over the course
Not a
of
big
weeks and
number.
weeks and weeks, by the end, and feeling so angry by the end, that's not a big verdict at all. That's totally what's fair and
Yeah.
reasonable in this case. Yeah.
They can
So
have
those are the
they
two things they've figured out.
Yeah.
They have to go for anger, and they've got to talk about money early and often.
Okay. So I've seen Inside Out, both one and two, so I completely understand how anger can be irrational and take over. I don't know if you've seen it. Fantastic Pixar movie, or I don't know if it's Pixar,
Yes.
one of those, just phenomenal. So that makes complete sense, right? So, wow, how do you even? And I'm trying to think, if I were, now I'm the defendant or I'm
Mm-hmm.
the defense attorney. There's someone that's kind of riling up, trying to use the keywords to lift the level of sympathy, lift the level of anger. Oh my God, how can you possibly combat that without making it worse, without
Yeah.
looking defensive, which, as you know, from a psychological standpoint, makes you look guilty when you're
Mm-hmm.
that defensive, but you got to defend yourself. So
Mm-hmm.
how do you even put up a shield or something
Yeah.
to to combat that level of verbal attack, basically?
Yeah. I'm going to put you back on the spot again, Nick.
Okay,
So, like,
okay,
and for your
let's do
listeners,
this.
right? So, let's take this. So, let's just take it out of the courtroom. Like, this is human psychology, right? There's not plaintiff psychology and defense psychology. It's human psychology. The same tactics that work for the plaintiff are going to work for the defendant. So, let's say you're just in an argument with anyone. It could be a friend, a spouse, a child, right? If someone's coming at you, throwing all these things you've done wrong, and they're angry, 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 yes. And you've got your shield up, and you're just saying, no, no, you're wrong. How dare you? It was so and so. How do you feel? Like, what does it feel like when you're trying,
Oh,
but you're so angry and you're just trying to get the
but
other person to understand?
it's frustration. It's fight or flight. It's like, why can I not get my point across? Why can't, like, this is so easy to understand. Why is it so difficult?
No.
Just
And you get
massive
so,
frustration.
yes, and you get so angry, like you're not even listening, you know? And so if the defense comes back with the shield up and isn't listening, isn't validating, isn't accepting responsibility, now responsibility and liability are not the same all the time, then the jury just sees this party that's unreasonable, that has their head in the sand, that is not operating in the same
Mm.
reality that the rest of us are, and they've got to send a message with the big verdict to get you to listen, right? So then,
That reminds me of a research paper years and years ago. I mean, this could be decades ago. I don't know. That said, in medical malpractice cases, doctors or hospitals, whoever the defendants were that apologized had much, much, much lower verdicts. Like there was an act of contrition
Mhm.
almost, and it sounds like the jury's being human can see that and understand, like, well, people make mistakes and they've owned up to it, so let's just move forward in this. It kind of blunts the anger almost.
That's exactly right. It diffuses it completely. And then the jury can focus on what we're there for, right? We're there to hold the defense accountable. If the defense has fallen below the standard of care, if they're liable, then we're there to fully compensate the plaintiff for the harm that they've
Hmm.
sustained. Not a dollar more, not a dollar less. We're not about getting a discount, but what we're there to talk about is what's fair and reasonable. That's what the law says. And we have a lot of arguments around
Yeah.
our number and things like that, but it, by accept our the way we phrase it is validating and accepting responsibility for something. And it doesn't have to be I accept responsibility that I messed up. It could be responsibility for anything, and it's kind of nuanced for the lawyers,
That you have
but
sorrow. I have sorrow that this happened. I did the best I could.
yes.
I feel horrible.
Right. Even if you think you did nothing wrong, put yourself in the plaintiff's shoes. For the defendant to be able to say, I know we disagree about how we got here or the cause of this accident or why this person was terminated, but I can validate that to be hurt and go through surgeries or to lose your job, that's awful. That's awful. We're so sorry that that happened. Now we've got to talk about how and why, but we understand that this is a very unfortunate and awful circumstance.
Yeah, so I'm going to quiz you right
Oh,
now.
yes, my turn.
Um, what's the most infamous nuclear verdict case that you think the public's aware of?
Oh, in my mind, okay. And what's crazy is that it's probably not a nuclear verdict, but the hot coffee case, the
Yeah,
McDonald's hot
McDonald's.
coffee case. Yeah, right?
That was a nuclear verdict. That was like
Back in the day.
back in the, wasn't it like $40 million?
So the thing is, oh my gosh, we're gonna have to Google it after this, Nick, because I feel like it didn't meet the $10 million threshold.
But
But back
you remember
then,
the uproar
yes.
around,
Yes.
and then you look into the details and there was a little bit more. Like McDonald's basically was serving boiling hot
Mm-hmm.
coffee, like unusually hot,
Mm-hmm.
right? And so they did send a message.
Oh
Although
yeah,
I've had McDonald's coffee, it's still freaking hot. Like it's unbelievably hot. Like
it
I don't know
really
how anyone
is.
can drink hot coffee like that. But I think society grapples with this because there is that sympathy, but there's also
Right.
like you spilt it.
You
Like
know,
you got in a car, you took the lid off, like you did a whole bunch of stuff here. And I think the public has tremendous difficulty because we don't know all the facts, but just trying to understand, like, what is fair, right?
hmm
And I think one of my big frustrations is that if you go court case by court case, you and I'm going to ask this question, like, is there doesn't seem to be a rhyme and reason. It seems like every case is its own independent thing. And I don't like that. I like science and predictability. And like it's binary. It either meets the standard or does not meet the standard. sort of thing. And it's a struggle, especially like you mentioned California, like state by state, this could be different. This this is like a legal, to me, like a litigation nightmare all over, because now it's like, okay, we can pick a state that's going to be more sympathetic to us. We can, like, there's so many different ways to play a game here, game
Hmm.
theorize this thing,
Hmm.
that that's the one part that completely frustrates me. It's not, okay, we're not, this isn't about the facts anymore. This is a game, and people are doing doing a draft and just trying to pick, I'm going to pick this player and we're going to pick this player,
Hmm.
and now we pick sides and all of this stuff. And I
Right.
think from a societal standpoint, we're confused, and we don't know like what harm this is doing to society, if any.
Yeah. Well, the game has completely changed, and that's why it's so hard, Nick, is because we used to have what we call these judicial hellholes, like
Oh,
downtown LA, Cook County, Illinois, the Bronx, right? Where it's just like, if you're in those venues, your case automatically has a higher value. I'm sorry, it just does, because if it goes to a jury, the jury of your peers in that venue is very prone and historically shows they're going to give big dollar values. But states that we have never traditionally seen nuclear verdicts are coming out with nuclear verdicts. So it's almost like, no, I hate to be like a fearmonger, but no jurisdiction is safe. I mean, defense counsel and insurance claims professionals, true, you got to be on your game, regardless of where you are in the country, because the plaintiffs bar, to what you said, they are so well organized. They are so well integrated. When something works for a big plaintiff's attorney in Texas or Florida or California, they're sharing it on the listservs. They go to conferences and share with each other. So someone from Minnesota, a plaintiff's attorney from Minnesota, will come and get this new tactic, and then it works there because it's human psychology. So yes, I wish we had better data to where, that's what the law is supposed to be. It's supposed to be individualized, which is yes. Yeah, absolutely right. But every case has to meet certain factors, and it has turned from just black and white facts into a psychological, and defense counsel, the defendants themselves, the claims professional in the case have to be prepared and ready to go.
wow. Which which lines of business are most open for business when it comes
Oh,
to nuclear
yeah.
verdicts?
I also want to say all of them, but particularly where we're dealing with corporate defendants, those are the biggest. So we're seeing the trucking industry hit very, very heavily. And these are our national heroes who kept supplies on the shelves during COVID. Like, people understand, I think, supply chain issues now in post 2020 so much differently. Nevertheless, the trucking industry continues to get hit. Medical malpractice is off the charts. Doctors and hospitals,
Always.
particularly where it leads when it involves a birthing injury or something involving children. Those are they're
Mm.
tragic and horrific cases, and those are hit very, very hard. A lot of states have changed the law around bringing old sexual assault and molestation claims. They've opened up the statute of limitations, like I know New York has and California has. I think I just saw something coming out of Louisiana where, the statute of limitations doesn't matter anymore, really. And you've got infinite number of time if you were abused as a child. And these, again, are horrific, horrific cases. And we're seeing the juries go to very big numbers here. But we've even seen just like, I mean, we're talking mom and pops. We're talking somebody trips on a sidewalk and trips over. We have seen a nuclear verdict in a store where the plaintiff tripped over the wet floor sign, literally fell over the wet floor sign, and claimed that the store was negligent, and the jury agreed. And it's like, what more do we need to do, right? The plaintiff's attorneys can always come up with more that we should have done. So
Mm.
and the thing is, because so many different lines of business are implicated here, your the cost of insurance for folks is going up, right? I mean, that's what we're all seeing.
Yeah, and but when you hear plaintiffs' attorneys talk about this, it's like, yeah, but this was well deserved, and the insurance companies are just being greedy, and
I know.
they could have fixed this before. And so I'll transition to Florida because it became a judicial hellhole,
Mm-hmm.
right? And what happened was the gamification was huge. There were there was third party financing. Like this was such a
Oh, it's still
slam
happening.
dunk that hedge funds, instead of investing in 30-year T bonds risk free, were like, I'm going to invest in litigation farming because it's so
Mm-hmm.
lucrative to be able
Mm-hmm.
to do that. And so in Florida, there was a special session in order to combat that. And now the trial attorneys, like they're very clever. They're using the we gutted consumer protections for the greed of the insurance companies. And I'm wondering, like, I guess that'll never end, but what can be done on the tort side? What can be done on the litigation side? And is there a difference between, like, can the federal government do anything, or is this truly a state by state thing?
So they're looking at it right now when it comes to litigation funding in particular, Nick. So, just what you said, litigation funding is outside third parties, hedge funds. We have foreign entities even investing in litigation across the company, across the company,
Country.
across the country. And it's
You got
not
there.
just, thank you, third time's a charm. And it's not just, mass torts, it's not just class actions, like it could just be single plaintiff huge cases. And what's crazy is that when they're investing in these cases, it actually can impact whether the case resolves through mediation or settlement before trial, because it's not the analysis at that point with so much money in the case isn't what's fair for these injured individuals, the
Yeah.
plaintiffs. It's what's profitable for the investors and the plaintiffs' attorneys. It's then there's a whole argument that
Well,
national security is at
yeah.
stake because we have national and international entities from overseas who now have access to what's going on in our judicial court systems.
And to put that specifically in perspective, just look at the heck this country went through after 2016 with the whole Russia stuff and
Mm-hmm.
their influencing of elections, their
Mm-hmm.
influencing of cases. Like I think it's pretty well documented that outside entities using cyber and other tools can wreak havoc on society culture by dividing people. And we've seen it in social media with the whole Russia thing. But it doesn't take a rocket scientist to figure out that, let's take a nation with really big pockets who's just like, we don't want to go to war with the United States, but we want to make them as miserable as possible. We fund all of this litigation, they're going to be fighting themselves internally, and it's
Yeah.
just going to make their society very divisive. I don't think
Mm-hmm.
people have connected the dots on how dangerous that is.
It's incredibly dangerous. So it has been handled on a state by state basis right now. Apple's actually fighting it out in court right now on whether these documents related to litigation funding in one of their lawsuits. I mean, bless their hearts, Apple gets sued all the time, right? But in this one particular lawsuit, they know there's litigation funding involved on the other side and they want all the documents and they're fighting about it in court. It has been, I know Louisiana just came out with a bill that was signed into law saying that if there's litigation funding in your case, their documents about that are discoverable. Like both sides should be able to know what's going on. And then Congress on the national level is looking at it as well. So
Yeah.
I think there's certainly hope, but this is, I mean, it's a multi-billion dollar industry that's practically unregulated right now. It's very dangerous.
Yeah. And it can harm the plaintiff, right? Which
Oh, yeah.
at the end of the day creates a potential conflict of interest. Of course,
Yes.
what'll be said is like, well, okay, Kate, I'm going to play devil's advocate. Well, we need that funding because the defendants have huge pockets and it's equalizing the playing field, is what I've heard around this stuff. But to the point that you said, it harms the plaintiff in that once an investor is in there, who controls the settlement on that? And now I've only heard anecdotal cases that the investors have an undue influence. Like, no, you cannot settle because we're into this thing. You got to push this along further. like massive conflict of interest as far as I'm
Massive,
concerned.
massive. And I think we've just got to come back to the basic point of our civil justice system.
Yeah.
And it's like, this is how we solve civil disputes in this country. We're not physically fighting it out. It happens in court and it happens through the payment of money. And as distasteful as that is, right, this is how we peacefully resolve disputes in the United States of America. And so if the focus of these lawsuits is taken away from what's truly going to make the plaintiff whole, and it is instead focused on profits for these hedge funds, for these international organizations or corporations, and for the plaintiffs bar themselves who are flying around the country in private jets. Wow, I'm coming in really hot on this podcast, Nick. Like, I'm concerned that we've lost focus on what justice and fairness and equity is. And so at our firm, when we're talking about going into trial in these cases, we're very focused on the psychological element that can direct the jury back to what's fair and reasonable and equitable.
You may not be able to answer this question, but from a civil justice standpoint and how we adjudicate these sorts of things, how can we encourage more mediation? How can we encourage arbitration? What are there any mechanisms we can put into place? Because they exist. We all know
Mm-hmm.
they exist, but like Florida has it. But when we had the litigation abuse, they
Mm-hmm.
were smart enough to know like if they got involved early, it was
Mm-hmm.
going to jump over arbitration. It was going to jump over
Yeah.
mediation,
Yeah.
right? And there's been a lot of statistics around cases that go to litigation just have settlements that are just like multiples bigger than if you had just settled up front. I think that's why a lot of insurers in Florida just decided, let's just settle this thing and be done with it. But it made them insolvent after a while. They could not
Mm-hmm.
keep up with that scale. What can we do to encourage more mediation and arbitration? And I think you guys are good to speak about this because that actually affects you guys. Like that affects your bottom line as well. But I have a feeling you are also amenable to more conscientious adjudication of
Oh,
these things, not
absolutely.
battling everything in court.
Yes, absolutely. I mean, if our just putting so our ethical obligation is to the defendant, right? To fully protect their interests. And 99% of the time, we are able to fully protect their interest and resolve it through a settlement, through whether that's mediation or informal negotiations, whether other alternative dispute resolutions like arbitration, that's a little more rare. But the vast majority of the time we settle the case. We are always interested in settling. Even going into trial, we're interested on can this still settle? I mean, just think of the emotional impact it would have on a defendant to sit in front of a jury for weeks on end. That's a hard thing to go through as a
Yeah,
human being. We want
yeah.
to spare them that as much as we can. But there are still those cases, I guess, at the end of the day that just can't be settled for whatever reason, and we're ready to try them. How do we increase? Oh, there's a lot of technology out there right now that's really trying to tap into how do we more fairly, efficiently, and accurately resolve these claims. And the couple of them that I've heard of are about bringing both sides to the table, and they're just not getting buy-in from the plaintiffs bar, right? But court
It's not in their
it's
interest,
not,
right?
I mean, it's in their client's best interest, maybe, but
Not
that
theirs.
yeah, and I mean, the same argument can be made about us, right?
Yeah.
Obviously, the longer we fight, the more we get paid by the hour, whatever. But it's just not the case in practice and in effect. So, I mean, we have many court systems, just so your listeners know, have mandatory settlement conferences. Whether you use the judge in your case or whether you choose to go to private mediation, like the vast majority of courts force the parties to at least go through some way to try to informally resolve it. And I want your audience to also know that they're successful. I mean, way less than 5% of litigated matters actually go to trial. The vast majority of them do settle. That's true. But let me bring this full circle.
There's always a but.
There's always a but because I'm a lawyer. There's always a but, and it depends. But because we're seeing these nuclear verdicts, right, the less than 5% that do go to trial are resulting in bigger verdicts. and more frequent higher verdicts, it's actually impacting the cost of settlement because plaintiffs' attorneys and plaintiffs themselves are emboldened. Well, if I could just, if I might as well just wait and roll the dice because I could get 10 times what you're offering me right here to settle.
It's a potential lottery ticket.
Yeah, it really is.
And
Yeah.
the verdict ultimately is consequential to society's insurance premiums,
Yes.
which is probably a conversation for another time, how that sort of matriculates. Well, we brought up nuclear verdicts, but I've heard new terms, Casey. I've heard
Right.
thermonuclear verdicts.
Mm-hmm.
Like, does it make sense to have some sort of cap on this? Like, is there an upper bound to this? Because this seems like it just can keep going on and on and on.
So thermonuclear verdicts we're hearing are those verdicts in excess of $100 million. And those are also increasing in frequency and severity. So, many states have implemented cap on non-economic damages, whether it's in all civil cases or just in a segment. So in California, we have one on medical malpractice cases, like protecting doctors and hospital systems. There's a cap on not pain and suffering damages there. And other states have different iterations of it. It's certainly, it's hard for me to say. I think that they're protecting businesses, like and protecting the economy and fully compensating the plaintiffs, probably. I mean, it's a state by state basis. I fully support that kind of tort reform. It's just a long-term play. It takes a very long time to bring about change through our legislature. Whereas I believe that defense attorneys and claims professionals have the tools today to change the trajectory of their cases today by tapping into these psychological tactics, principles, methods that the plaintiff's attorneys are using to connect with a jury in a better way and stop the nuclear verdicts on the front lines where it happens, and
Okay.
that's in the courtrooms every day.
And that's how I was thinking we could end this particular conversation is for I'm hoping a lot of corporate folks end up seeing this, but it's likely to be predominantly on the insurance side of things. But can you be proactive? Are there, you talked about tapping into technology, but are there particular things that can be done to try to head off any steam that's sort of leading to this? If I were on the other side, if Casey, if I had big pockets, I wouldn't want a nuclear verdict, right? So I'm going to buy an umbrella
Right,
policy. Like I'm
right.
going to do some things, but man, what can an insurance company do to potentially ward this off?
Yeah,
I'm just going to kind of end the conversation, just kind of throwing that out and just getting your opinion on
yeah.
that.
Well, the number one question we've received from claims professionals since we wrote the book, Bob Tyson wrote the book, Nuclear Verdicts Defending Justice for All, is okay, I'm handling hundreds of litigated claims on my desk. How do I identify which one could go nuclear?
Yeah.
And so we worked with data scientists and we pulled data from tens of thousands of verdicts, and we have an algorithm, an AI-based algorithm that is a product that connects with existing claims management software, and it runs continuously in the background and will tell you on a daily basis what your nuclear verdict risk score is as a claims professional. You'll know, and it's a small percentage, right? It's a small percentage meet all of these criteria, but that file's not going to slip through the cracks. You're going to make sure you've got the right defense counsel on it. You're roundtabling it with your supervisors and your managers. It's called Schaefer City Technology. Check us out. Business Insurance just awarded us 2024 Innovator of the Year for this. We're very excited. And I think that's going to stop things back of the house. Front of the house, like defense counsel in front of a jury. Please read. There are 4 things we say you should do very quickly. You've got to accept responsibility for something. You have to personalize your corporate defendant and tell the corporate story. You have to give a defense number, and you have to argue pain and suffering. You have to have an argument for why a pain and suffering number sponsored by the defendant is going to make the plaintiff whole. And when you put both of those things together, right, on the insurance side and the defense counsel side, we believe you're doing every single thing that you can do to stop a nuclear verdict. And what's fascinating is, final point, We've analyzed 100 nuclear verdicts for book number 2 on what the data says is happening in the courtrooms behind the scenes. And not a single nuclear verdict did the defense use all 4 methods that I just said. So it is working. The data supports it. And we've got to be collaborating with each other and sharing the information. So thank you so much for giving me this platform, Nick. It's been an honor.
Yeah. So essentially you're saying you got to fight fire with fire.
Fight
So
fire
use
with fire.
technology, data, analytics, predictive modeling. Got it. So we're going to walk away with that. Cayce, I am going to add your contact information, a link to the book, and everything else in the show notes. But this has been illuminating. And listen, when book 2 comes out, if you guys aren't on this show, you guys could be facing a nuclear verdict. So I want you guys back.
1,000%. It would be my honor. Thank you so much, Nick.
Okay, thanks, Cayce.